Part 7. The WordPress War, When Infrastructure Becomes Leverage. A sourced look at cloud economics. Every claim links to its source. Nothing here alleges a crime. The striking part is that it is all legal and disclosed. Most of this series has been about giants: Microsoft, Amazon, Google, and the levers only giants can pull. This part is smaller, and in a way more instructive. It's about what happens when the thing you depend on to run your business is controlled by the company you compete with. That's the WordPress story, and it ran straight into a courtroom. To be clear up front, what follows is a fight that is still being litigated, in which one side's biggest accusation has already been dismissed. I'll keep those two things straight, because the case only makes sense if you do. WordPress powers a huge slice of the web, and most of the people running it never think about where the updates come from. The repository of plugins, themes, and software updates that keeps millions of sites patched and alive. Is not a neutral utility calm. WP Engine is a large, independent WordPress hosting company, a competitor that depends on that same shared infrastructure. So when the relationship soured, the question wasn't abstract. It was, who controls the pipe and what can they do with it? The break was public and fast. Mullenweg called WP Engine a cancer to WordPress, and Automattic demanded that WP Engine either license the WordPress trademarks or pay roughly 8% of its revenue toward WordPress development. Resources was blocked. TechCrunch. WP Tavern. Sit with the mechanics for a second. A company asked a competitor for a cut of its revenue. The competitor said no. The shared infrastructure that competitor relied on went dark. Whatever you call that, it's the clearest illustration in this whole series of infrastructure becoming leverage. District Court for the Northern District of California, WP Engine, Inc. v. Case No. 324 CV 06917, before Judge Araceli Martinez Alguin Court. Listener docket. Complaint, Doc. 1. In that complaint, WP Engine alleged extortion and abuse of power, including a threatened scorched earth nuclear approach, to coerce it into paying for the WordPress trademarks. TechCrunch. Courthouse News. Read those quotation marks carefully. Extortion and scorched earth nuclear approach are WP Engine's words in WP Engine's filing. Allegations, not findings. Hold on to that, because the court's view of the extortion claim turns out to be the whole point of this piece. This is the part that is not an allegation. It's a court order. On December 10, 2024, Judge Martinez Alguin granted WP Engine a preliminary injunction or access to its September 20, 2024 state, restored WP Engine's control of the Advanced Custom Fields ACF plugin, remove a login checkbox that required users to disclaim any affiliation with WP Engine, and stop interfering with WP Engine's plugins. TechCrunch. The Register. In granting it, the court found WP Engine was likely to succeed on its intentional interference with contractual relations claim, and faced irreparable harm without relief. WP Tavern. One word does a lot of work there. Likely. A preliminary injunction is a stopgap to prevent harm while the case proceeds. Likely to succeed is a preliminary assessment for that limited purpose, not a final ruling that interference actually happened. Early lead, not final score. Then the case turned, and it turned against WP Engine's headline. On September 12, 2025, the court granted in part and denied in part the defendant's motion to dismiss. It dismissed WP Engine's attempted extortion claim under California law, in the order's own words, without leave to amend, and knocked out WP Engine's Sherman Act antitrust and monopolization counts. PPC Land. Search Engine Journal. Without leave to amend is legal language for don't bother trying again. The door on that claim is shut, so the single most quotable accusation in this whole saga, the one that made the headlines, extortion, failed in court. It was an allegation, the judge rejected it, and it is not coming back. I want to be the one to tell you that plainly because a lot of coverage isn't. If you only remembered the dramatic word, you'd have the story exactly backwards. What survived the motion matters too. The intentional interference, Lanham Act trademark, and defamation-related claims were allowed to proceed. Search Engine Journal. Automattic and Mullenweg have disputed WP Engine's case from the start. Automattic called the complaint meritless and a gross mischaracterization of reality. Automattic.tt. On the extortion and antitrust counts, the court's dismissal backs that characterization up. The accusations also run the other direction. On October 24, 2025, Automattic, with the WordPress Foundation and WooCommerce, filed counterclaims alleging that WP Engine infringed the WordPress and WooCommerce trademarks, engaged in deceptive branding and false advertising, and never honored a pledge to commit 5% of its resources to WordPress. Automattic. TechCrunch. Those are Automattic's counterclaim allegations, filed, but not adjudicated, and WP Engine denies them, and the blast radius reached customers. A separate proposed class action, Keller v. Automattic, No. Org access between roughly September 24 and December 10, 2024. The court dismissed that complaint for inadequate pleading with leave to amend, and the plaintiffs refiled Tico and Zavary. Court listener docket. Opinion. Michael, I'm not telling you anyone is guilty. A court rejected the extortion framing, bluntly, without leave to amend. And I'm not going to relaunder a dismissed claim as if it were a finding. What I keep looking at instead is the architecture. When the shared infrastructure an entire ecosystem depends on is controlled by one of the competitors in that ecosystem, the access switch is also a negotiating switch, and it doesn't take a villain for that to be dangerous. The early injunction is the tell I come back to. A judge looked at the cutoff and decided, even temporarily, that the lights had to go back on. The legal labels, extortion, antitrust, interference, will get sorted by the court, and some already have. The structural lesson won't change either way. Bad systems, not bad people. You don't have to take my read. The docket, the injunction order, the dismissal, and both sides' own statements are linked above. Judge them yourself. Every number in this video is in the company's own filings. You do not have to take it on faith. Check each source yourself at the Evidence Explorer, linked in the description. This was part 7 of a source series. Bad systems, not bad people.